Welcome to the McNeese Labor and Employment Podcast Series. This podcast will address protected activity under the NLRA by Adam Santucci, attorney at law. Mr. Santucci practices in the Labor and Employment Group at McNeese.
Hello. Thank you for joining me for this podcast. I'm going to talk about the protections afforded to employees under the National Labor Relations Act and how you can help your organization stay out of the crosshairs of the National Labor Relations Board. The Act covers nearly all private sector employees in the United States and protects employees' rights to unionize, to join together to advance their interests, and to engage in other concerted activities for purposes of mutual aid and protection. Collectively, these are known as the protected activities under the Act. Key to our discussion today, the Act makes it unlawful for an employer to interfere with employees' ability to exercise these rights. Historically, the Board has taken an expansive view of the definition of protected activities and has found that the Act protects things like making complaints on behalf of a group of employees and employee discussions regarding the terms and conditions of employment, including such things as wages, working hours, safety, and even supervision. These actions are viewed as a sort of precursor to union organizing activity. The Board and the courts have declared that employer policies that restrict or prohibit these activities are unlawful. Therefore, a policy that prohibits employees from discussing wages, for example, which is a term and condition of employment, would be unlawful. Also keep in mind that the Board and the courts will declare a policy unlawful if an employee could reasonably believe that the policy prohibits protected activity. In addition, policies that are adopted as a result of union organizing activity or policies that are implemented in such a way to prevent protected activity would also be declared unlawful. Unsuspecting employers, many of which are non-union, have recently found themselves the subject of a complaint before the National Labor Relations Board. Often, these complaints challenge the employer's policies or employee disciplinary actions implemented pursuant to such a policy. Please keep in mind that the Board has jurisdiction over most private sector employers, whether or not its employees are unionized. Recently, the Board has taken an even more expansive view of protected activities and has declared a number of traditionally non-controversial employer policies unlawful. For example, confidentiality policies, employee conduct policies, policies requiring employees to maintain the confidentiality of internal investigations, email policies, social media policies, and others have been struck down by the Board. And employee disciplinary actions issued pursuant to these policies have been reversed. As a result of the Board's overly expansive definition of what is protected under the Act, employers must take a hard look at their policies, procedures, and employee handbooks to determine whether or not they have any policies that may be unlawful. Employers must take into account the Board's new, expansive definition of protected activity when crafting or revising policies, and many employers are considering a disclaimer in order to make clear that their policies will not interfere with rights protected by the Act. To the extent that you identify any concerns when you review your policies, you should work with Labor Counsel to revise those policies to ensure that they will pass muster and keep you out of the Board's crosshairs. If you have any questions regarding the scope of the Act's protections or how your organization can draft lawful and compliant policies, please contact us using the information on the screen.